What's up, everybody, and welcome into the final pretrial for Donna Adelson before she goes to trial next week. And in this pretrial hearing, we're going to hear about some of the evidence. They're still arguing about whether or not it's going to come in. We're going to hear about some evidence that has not been used in any of the other multiple trials we've had dealing with this conspiracy. So that's going to be interesting to talk about a little bit. And we're also going to get the trial schedule because while it is starting next week, we will not be doing videos on this trial for the majority of next week, as that's going to be jury selection. We'll discuss all that and more, talk about whatever your questions are, hit the like button, and let's get this thing started. So the first argument they discuss, we're not going to listen to the entire thing, but basically one of Charlie's old defense lawyers, either side may want to ask him certain questions. The state thinks certain things are relevant to prove conspiracy, such as a potential offer to pay for the Adelsons to pay for the legal fees for Catherine Benoit. And the attorney is actually on the phone. He filed a motion to quash the subpoena. He doesn't really want to testify. It doesn't seem like he doesn't see how these things are going to be relevant. The defense says if they're going to ask him those things, we need to ask him other things. Of course, both sides are objecting to anything that's attorney-client privilege. So we're going to pick up in the video when the judge makes his ruling on this specific witness, whether or not he's going to be allowed to testify. And then we're going to roll that right into them discussing these specific pieces of evidence that they have not agreed to yet. Some of it's going to come in, some of it's not. Some of it the judge is going to reserve ruling on. And within this judicial ruling here we're about to hear, and also their discussions of the other evidence, we get to hear what the schedule is for the trial that is beginning on Monday. And yes, they're going to talk about jury selection. In a case like this, it's going to take longer than maybe you would have originally thought, but it is a high-profile case, and it is a case that has been tried multiple times with different defendants, even multiple times within one defendant, right? McBanoel had 2 trials. And so there's going to be a lot of people that already know about this case, have preconceived notions, and that is the really important part about this case and picking the jury. And that's why it's going to take longer than you may expect if you just watch normal trials that are not as high profile or have other companion cases that have already been tried within the same jurisdiction, meaning the same jury pool potentially. Like, it's very possible they get somebody that was dismissed on another case, comes here for this case, they're going to have to dismiss them again. And, that can make things take longer.
In some way is going to argue this goes to conspiracy. They'll be given an opportunity to do so. If an objection needs to be raised, you may do so contemporaneously during the trial itself. So Mr. Marcus has a better opportunity to plan. The parties know when he would actually need.
All right, sorry, we just got to the schedule. He granted it. He's going to allow him to testify as long as it's appropriate, not attorney-client privilege and relevant. But now we get to hear what the actual schedule is for the trial.
To testify. I'm sure he has a very busy schedule, and we're not trying to create a hardship or inconvenience as it relates to his work and business.
As soon as the state rests, the defense intends on calling him.
Ron, I believe your previous estimate, Ms. Kappelman, was 6 or 7 days.
Yes, sir.
Let's pinpoint on the calendar then at least a projection that will assist the witness in determining when he would need to be present. Jury selection begins next week on the 17th. If we have a jury by Thursday the 19th, the first day of trial would be Friday the 20th. And that means by Friday the 27th, potentially the state is resting its case, which would lead us then to Monday the 30th, the beginning of the defense case, unless I'm off of my calculations.
You're correct, Your Honor.
You're correct. When the defense.
So while it's starting Monday, what is that, September 13th, 14th, 15th, 16th? It's starting September 16th. The first day of actual trial with the opening statements is probably not going to be until September 20th. And I think that even builds in an additional day of jury selection if they need to. So at the very latest on the 23rd would be opening statements, but that's at least 4 days for jury selection. And I think they're going to need every bit of it. I'm trying to remember if this was the trial last time that they actually picked the jury sooner than we thought. I can't remember. There was a high profile case where I expected it to go much longer picking a jury, and it wasn't. It was actually pretty quick. But they got there. They got the jury. they got the job done. And they moved on with the case, which I think is, like I've said before many times, the most important part of any case is picking the jury. So then if testimony starts on the 20th, the state thinks 6 or 7 days. So that puts us to the 27th, which is the next Friday for the state's case in chief. So basically 1 week for the state's case in chief. Maybe it bleeds into the next Monday. Then the defense starts their case on that Monday. They'll probably have a couple days. So, I mean, we're probably looking at, if this thing starts on Monday, which I believe it will, within 3 weeks, we'll be done picking a jury, state's case, defense case, closing, and verdict. I think there's a real possibility this thing is done in 3 weeks, which, would be great. That's a good schedule if they can get it going. I think there is a holiday that they bring up later in the midst of it. So there might be a day off from the trial, but that's what the trial calendar looks like. We start Monday, but the real trial doesn't start, meaning from what you guys would want to watch with opening statements. We may or may not do an update during jury selection. If you guys want to, you can let me know. Trial starts, opening statements next Friday, so a week from tomorrow. And then we're fast and furious for the next, 2-ish weeks until we get to a verdict. So we're all on the same page. You guys can set your calendars. We'll have to see who's streaming this. I don't know. I haven't heard, which of the trial streamers out there are streaming this. I'm sure all of our favorites are. So you guys can figure out where you want to watch it, where you're going to come here for or from each night for the recap and reaction and to get all of your questions answered. But let's listen now as they kind of continue to discuss the schedule, and then they get into what will and will not come in at evidence, or at least what they agree to at this point between the defense and the state.
This has a bit of a time pressure also because of the Jewish holidays.
Mr. Marcus, if you can go ahead then and mark on your calendar as to when you may potentially be called, starting with September 30th. If there is any hardship that you need to address in other cases or matters that you're involved with, please let the parties know. If it's another state court matter, perhaps I can pick up the phone, free you up.
Thank you, Your Honor. I am doing federal court on the 1st, but I'll work with the parties to see if I can get called on the 30th if it's actually going to happen. I suspect, Your Honor, that when the factual issues come up in trial, that there will be some debate about whether these items should come in, because again, I'm not as plugged in as everybody here, but it just seems that the 3 topics don't go to any actual conspiracy theory, but I'm hoping that when the objections are raised, they may.
This is the lawyer who's actually being called to testify, arguing. He said, I don't think any of it's going to be relevant. I think when the facts come out, you're not going to let them call me to testify. So we'll have to see, but he doesn't seem like he wants to testify, nor does he seem like he thinks it's appropriate for him to testify.
I'll see if I need to call on the 30th.
All right. That concludes the motion to quash the subpoena. Have a good day, sir.
Thank you, Your Honor.
Trial subpoena is denied as to all factual issues.
Or something like, if you want presentation as to hearsay and attorney-client joint defense privilege, we could go ahead and take those up now.
Go ahead.
May I approach, Your Honor?
You may.
Judge, it's changing the document, so it's based on what I have so far. So there may be more that comes up in trial, but based on what I have right now.
You've reviewed it all, correct?
What's that?
You've reviewed all of it.
I've reviewed all that we have as of now.
Right, go ahead.
So I think it's page 20. It's an email between Donna Adelson and Renee Griggs. And below it, it's in response to an email from Renee Griggs to Donna Adelson. It's hearsay.
What is this being offered for?
So there's an email between Donna and Griggs, and he's saying it shouldn't come in because it's hearsay, and we're going to hear their arguments back and forth and eventually get to the judge's decision.
Judge, in that email, the defendant explains that she is stressed about her daughter not being able to relocate, that her daughter, I think, doesn't realize how much it will affect her life, Don Adelson's life, their whole family's life if this doesn't happen. The comments from the counselor that are concerned about her stress levels, I think, just add context. That's what we would be asking for the whole email to be admissible for.
So they're saying they just want to bring it in because they want to show how stressed Donna Adelson is.
So you're not offering it for the truth of the matter asserted, or you're offering it as a party opponent admission of some sort?
Yes, we're offering Donna Adelson's comments as admission by a party opponent, also a statement against interest about how stressed she is about her daughter not being able to relocate and how much it will affect her family if it doesn't happen. The therapist, or the, not therapist, life coach's comments that are also contained in the email would only be there for context.
Very well.
The therapist, sorry, not therapist, life coach's comments are only there for context. That's where it gets shaky. Obviously, Donna Adelson's comments from an email are going to come in. That's party opponent. Those statements are going to come in. That's an exception to hearsay. But my guess is what the defense doesn't want in is Griggs' statements. I don't know how important they are. Again, sometimes it's hard to go through this stuff, which is why I like it at trial, because usually we see it on the screen. We know exactly what it says. So right now we're trying to kind of guess what's being said here and there. And there's, some stuff we're going to talk about later when the officer testifies that we don't really get to see what the summary report looks like. So it's hard to have an opinion at this point, but we'll go based off context clues from what they're saying that we can hear.
Well, as to that point, Mr. Rauschenbaum, I will permit slide 20 if there is any limiting instruction that you wish to give concerning Mrs. Griggs' responses as only providing context to what the admission may be, that would be appropriate. But if these are party opponent admissions, they are permitted.
Judge, may I briefly just respond to be heard?
Go ahead.
The problem isn't Donna Adelson's comments. We don't have a problem with that. Those are statements against interest, and they're not confusing at all. They say exactly what they just said. The problem is Renee Griggs' email to Donna Adelson, which is hearsay. It doesn't give any additional context to what she says. You can understand Donna Adelson's admissions by her email alone.
So you're saying part then of this is just a response from Griggs to your client?
No, it's a chain, right? So it's a chain of emails between the two of them. We have no issues with Donna's part of the chain coming in. The problem is Renee Griggs' chain it's not confusing what Donna's saying. I can read it to you. She says exactly what they just said. So if you never heard what Griggs says, she says, I'm stressed about my son, but honestly, I'm more stressed about Wendy and what will happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk. Hope your mother is doing better, or at least stable, Donna. So if you just allow that in, which we don't have an objection to, that's a statement that Donna Adelson's making, you're okay. But
Does Griggs respond from there? Does your client respond from the response?
No, Griggs doesn't respond from there, but Griggs' email below is, hi, Donna, I'm not sure, and I only have part of it, but I'm not sure if you're back from your trip yet or not. I planned to check in yesterday. However, my mom was in the hospital and I was handling family stuff, so I was a bit out of pocket. More than anything else, I want to see how you're doing. It seems as though you have a great deal of weight on your shoulders. I could both hear and feel it on our phone conversation the other day. I'd really like to be able to help you shed whatever it is that feels so heavy. Please know I'm thinking of you and looking forward to our work together whenever you're ready. Take good care, Renee. I don't see how that isn't blatant hearsay without any exception. It doesn't, you understand again, the relevance that they just put it in for is exactly what Donna Adelson's email says, which we don't have a problem with that piece of it.
Ms. Dugan, what exactly context is being provided by Mrs. Griggs?
So I agree with the defense here. And there are some arguments I'll agree with the defense throughout this hearing. Some I'll agree with the prosecution's theories. Sometimes I'm with the judge, sometimes I'm not, but the defense is right. Donna Adelson's statement should come in. I don't think there's any reason for Griggs to come in. I don't even remember how the judge rules here, but I don't see any reason for his to come in.
First email before Ms. Adelson responds.
So the defense, I think, accidentally, when they read about, yes, I'm stressed about my son and my daughter, she doesn't get relocation and how all our lives have changed drastically. That was Donna Adelson's email. The last email he read was from Ms. Griggs. In that email from Ms. Griggs, who's the life coach, she basically is just saying, I'm checking in on you. You seemed last time to have a great deal of weight on your shoulders. I'd love to help you. And that's when Donna Adelson talks about how stressed she is and how much their lives will change drastically. So I think that the life coach's email just gives Ms. Adelson's comments a little bit of context as far as explaining why she's kind of pouring her heart out there and explaining why she's been so upset.
How much further does this chain go beyond?
I'm not seeking anything more than this page. I think there is more of this chain, but this is the only page I'd be asking for.
I'll reserve ruling on this from now. I'll look at it again when I have my thumb drive.
That's why I don't remember what the judge ruled. So he reserves ruling on this, what part is going to come in. I don't see why you need to let Griggs' part comes in. Honestly, I don't know why the state's even fighting this. The important part that they want to get in is Donna Adelson's statements. Those are obviously coming in, but it is what it is. And this is what happens sometimes in criminal trials. And we'll have to see later if the judge ends up letting it in.
Review the slide in its entirety. Go ahead.
Judge, I think the next item we have, I think we've got new slides on this, but I'll go, I think for ease, we'll go on the slides that you have because it's the same issue. If you go, it's slides 255, we don't actually have new slides on this, I apologize. It's slide 255, where Agent Corbett is estimating how long travel takes. We're moving to exclude that based on speculation.
Stugan, did Sergeant Corbett do any calculation or in some other way develop this information that can be demonstrated as reliable?
Yes, sir. So on this slide, we have actual versus optimal travel of Wendy Adelson on the day of the crime. The actual.
So they're arguing now about, travel estimate type stuff. What can they testify to? What can't they testify to? And the judge is like, is this reliable? What's he basing it off of? Is he just guessing?
Travel is based on the events in her call detail records, where it shows cell towers that her phone is communicating with as she leaves her house and goes on her way that day from by the crime scene to ABC liquor store and up to lunch. That's based on call detail records. And also other evidence like an ABC receipt that she had that day. For the red dotted line, that's the summary of the shortest route. So we're saying this is the actual route versus the shortest route she could have taken from point A to point B, her home to where another liquor store is in the restaurant.
And we know how this stuff comes out of trial, how this was used, how I think a lot of you guys, when you heard this evidence, like, why would she drive that way? Why would she drive that route? The way she explains it, the way the defense explains it, is that's what she was used to. That was her normal route before, was to go by that house and, where Professor Markell lived. And so, that was kind of their explanation, but it was a little side-eye, a little sus. So I think it is important evidence for the state. I do agree with them. I think that they're allowed to put this evidence in and just explain the two options and that she picked that option. And I don't see an issue with what the state wants to present here personally. So I'm with the state on this one.
What he uses to show travel time or miles is a company called, or a mapping company called Esri, which is, and if you need to hear more about it from Sergeant Corbett, he'll be here in just a second. But basically that is a software that Florida Department of Transportation uses for their mapping and mileage calculations. He uses this very regularly in all of his mapping and travel calculations and all of his presentations. And he knows it's reliable because several times he's tested it himself. He looks at where the map says the travel time should be in the miles, and he does the drive himself. So he's been able to personally test this several times, and it's been accurate. And what we have in this slide is, one is call records. The other is the summary of the shortest route. And it's literally just saying, hey, this is point A, this is point B, and this is the mileage according to Esri, and this is the minutes it should take. And it's twice as long as the actual, or twice as short as the actual route.
All right. The sergeant also will be able to testify as to his knowledge of this program, its use, and the fact that he is qualified to use this program.
Yes, sir. And I can ask him those questions today if you'd like me to, but he regularly uses this program and has knowledge of it, is qualified to talk about it, and has had personal knowledge of testing its accuracy before.
All right. On this issue, Mr. Rauschenbaum, you're essentially objecting that either the sergeant does not have an accurate calculation or in some way misuses the program. What exactly are you getting at?
May I have one moment, Your Honor?
Go ahead.
Judge, the objection isn't as to his knowledge, and you know what, we'll withdraw the objection.
Very well.
Rather
Let's move
cross
on.
the line.
They withdraw their objection. Okay. I forgot about that too. I did watch this, but I don't remember the outcomes of a lot of them. I just remember a lot of the content and context of what they're arguing. So he is going to be allowed to testify to that. Again, they already have a response drafted for that. Not a surprise. Lori was Donna's husband involved. So that's Harvey Adelson, Charlie's dad, Wendy's dad. He's in a lot of the text messages, in a lot of the discussions. He hasn't been indicted yet. You'll hear his name throughout this trial. I mean, the answer I would have to this is just, I don't know. Peter, what's your impression as Georgia as prosecutor? I think she's good. I think she's really well prepared. I think she's really confident. Again, back at the trial, most of the things that people remember, and we have mutual friends, me and Georgia and I, Miss Koppelman, I should say. I don't know her personally, but I didn't think the cross went great with Charlie Adelson. Parts of it I thought were great. Parts of it I didn't think were great. And that's what most people talked about, that they thought I did not think she was great, but I do. If you listen to throughout the rest of the trial, and just as I sit here now, and continuing to watch her and see how she works and what she does and how she's methodically gone through this case, because it can be complicated, but I think she actually does a really good job of simplifying it, almost like a Lifetime movie is what's going on here. And it's wild, but it's true. So I think she does a really good job.
Judge, the next one, and let me just confer with my co-counsel for 1 second.
Go ahead.
Judge, the next one is page 318. Some messages between Charlie Adelson and Donna Adelson. Charlie Adelson's messages are hearsay, and they're not in furtherance of a conspiracy.
Response, Sue?
Yes, sir.
I could just give you the date of the messages too.
Go ahead.
The date is August 2nd, 2016, which is after the arrests of Secreto Garcia and Luis Rivera.
Stugan?
In the motion, defense also objected to this on the basis of joint defense privilege. Is that no longer being argued?
It's not that. The document we objected to on behalf of joint defense privilege is hold on, let me just double check. Is a different one, and we're going to withdraw that objection given the court's ruling earlier today.
Okay,
This doesn't have to do with that because it doesn't mention
this
Mr.
is just
Marcus.
hearsay. Okay.
It's just hearsay.
All right. So, Judge, on page 318, what we have.
A joint defense privilege is just like basically like attorney-client privilege between defendants that are working together and have a joint defense agreement type of thing. They can discuss things without waiving attorney-client privilege, where if there was normally a third party in there, you would waive attorney-client privilege. But the point is they're basically saying Donna's comments can come in, Charlie's can't because he's not the defendant in this case. He is a co-conspirator. So if they're in furtherance of the conspiracy or discussing the conspiracy, then it can come in under different exceptions to hearsay. But generally, they're trying to just keep certain things out. And we know there's like hundreds of thousands of pages of emails and texts and transcriptions of conversations in this case. So they're just trying to pick and choose certain ones they think they can keep out.
Have our co-conspirator statements. This text message it says, this is from August of 2016. So this is going to be after the arrest of Garcia and Rivera. It says, from Charlie Adelson to Donna Adelson. Did you see in the paper where the state star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs and just in the wrong place at the wrong time. Maybe the coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. This whole thing is just crazy. Then Donna Adelson goes.
So those statements by Charlie Adelson, okay? Do you think that that's furthering the conspiracy? Well, maybe not at first glance. But the first thing I thought of when I heard these statements here is I thought you knew what was going on at this point, right? You knew it was blackmail and extortion, and you knew these guys and how it was involved. You knew it had nothing to do with Danny. You knew it had nothing to do with a drug deal. You knew it had nothing to do with that. So what are these text messages to Donna Adelson? I don't understand. So they impeach the overall defense. If the defense is going to go with the same story, they don't have to. I think they are going to. But of the extortion, they had to. Donna didn't really know what was going on. Charlie was telling her, we need the money. We were paying this, paying that, whatever it may be. But that's the first thing I thought when he's just like throwing out all these random ideas. It's like, I thought you knew exactly what was going on at this point, Charlie.
Goes on to say, I didn't see which paper. Charlie Adelson says, Tallahassee Democrat. Miss Adelson says, wow, I stopped reading everything. Charlie Adelson says, the guy admitted to selling them cocaine and hanging out with them. And Donna Adelson says, OMG, exclamation point. Our argument would be that this is co-conspirator statements. This is nothing more than co-conspirators celebrating another possible explanation that does not involve them for this crime. They are theorizing about another possible explanation for Dan Markel's murder. And this is showing just their theorizing and celebration of something that doesn't involve them that could explain the murder.
So she basically said it's co-conspirators celebrating the fact that the heat is off them and pointing the finger at other people.
In response.
I just don't understand it. I mean, it is. I mean, I can show you the text messages in its entirety if you would like me to bring it up, but that's not what's happening And I don't even,
I'll review it with my thumb drive as well when I go through slide deck. Problem, Ms. Dugan, that I'm drawing with.
I didn't love her initial explanation, but she gets there eventually, which I thought was kind of cool because that's not, I didn't think it was really like with that first argument, but when the judge digs, I think this is a really smart judge, by the way. I love, so later on, I can't remember what he says. Oh, eventually he's like, one person argues at a time, but he says it so calmly. Seems like his heart rate doesn't change at all, but he controls the courtroom with his voice without getting loud, which is the best way to control it, especially as a judge. But they get to kind of a better explanation, I think, than her initial one here in a second.
Those. The communications do not have to be so overt as to saying, we're hiding the gun here or something of that nature. But them essentially mocking, I guess, the drug dealer or the fact that someone else has been arrested in furtherance of their conspiracy. I guess flesh that one out for me a little bit more.
Well, also, I mean, their defense is that they were extorted, and this message pushes back on that. At the time this text was sent,
Don't
Garcia
speak over each other.
There it is.
and Rivera had been arrested already. So Donna and
I
Charlie,
think Rashbaum knows that's the better argument. So he was trying to like stop her from it because she already made her argument first. But now she's like, well, it pushes back on their defense.
Adelson would have known the people behind Dan Martell's murder. And now those people are behind bars. And now, so why, if they've been extorted by these people for the past several years, why are they theorizing about another possible explanation for this murder? They know what happened to him. Those people have been extorting them for years and they're arrested. Why are they now trying to say maybe he was killed by a cocaine dealer for stiffing him? Why are they theorizing and celebrating something that doesn't involve them?
All right, so I follow your logic. You're not offering this for the truth of the matter asserted, but rather to rebut any theory the defense is planning to present about a extortion conspiracy of some sort.
Right. Yeah, I'm not offering it to show that the state's star witness was a cocaine dealer. Maybe Dan Martell was killed by a cocaine dealer, or that's what Charlie Adelson actually thought. It's to push back on extortion.
As to the basis of which is being offered, Mr. Rauschbaum, what is your argument?
the key is you got to look, and I'm happy to hand it up to you. You have to look at what Donna Adelson says. She doesn't say any of that. She's asking what paper, and I don't know what you're talking about. So it's Charlie Adelson's statements after the conspiracy, the alleged conspiracy, after the arrest, after the murder, and Donna Adelson doesn't respond in any way to what he's saying. She doesn't have a clue what he's talking about.
All right, as to this slide, I'm going to reserve from now. I cannot ask you to show your defense or what you plan to argue, but ultimately, if any way, if it comes down to your client was relying on the statements of Charlie Adelson in some way concerning her behaviors and how she conducted herself and whether she in fact knew of the extortion. If the state plans to rebut the extortion theory of the defense, it is permissible as to that basis.
Absolutely the right call by the judge. If you guys start arguing extortion, if you guys go down that road, this is absolutely relevant to rebut it. And so it's going to come in if that happens. If you have a different theory and whatever, and maybe this whole conversation is not relevant, then fine, maybe it won't come in. But I think the judge was spot on here.
But not for the truth of the matter asserted. If a limiting instruction needs to be given, that will be given as to that specific slide. You may continue.
The next one, Your Honor, I don't have a page number. Let me see if I can figure it out. I think it's 321. It's very small writing, and it involves text messages between Donna Adelson and Wendy Adelson after Charlie Adelson's conviction. Again, the text messages by Donna Adelson are fair game, but the text messages by Wendy Adelson are hearsay. And
Response.
the timing of it is critical. It's after the verdict. It's actually the hours after the verdict in Charlie Adelson's case. So I'm not sure how it could be in furtherance of a conspiracy.
Okay.
So I think that and we may be able to come to an agreement on this. I think that I'm going to, there's several messages between Wendy Adelson and Donna Adelson in this chain. I would only be using from when Donna Adelson says, prayer hands, we shouldn't have to pray. He's telling the truth. He protected his little sister from years.
She says, prayer hands pray. We shouldn't have to pray. He's telling the truth.
Your brother protected you for years. Now you're not guilty. I wouldn't be offering anything after that. So I think the only thing Wendy Adelson says in the meantime is, I love you. Call me if you can.
If that's all, then we're okay with that.
How about that? Let's move on.
Judge is like, how about that? We came to an agreement, and this happens all the time, where you think you're disagreeing, you're fighting about everything. The state's putting in everything they might end up using, and then when the defense tries to whittle around the edges, they're like, actually, that's fine. We agree with you. We'll just use that. That's what happened there. Nothing makes a judge happier when they don't have to make a call and everybody's working together, and we got some kumbaya going on as we work towards this trial.
Okay. The next one is page 324. So
We can come to an agreement on this one too.
Hey,
we're on a roll here. So you're not using.
Do we need me any further? Call it a day?
Judge is like, can I leave? Are you guys good?
I'm not going to use that one in the presentation.
Okay.
I tried to give them all the things that I could possibly use and have to try to whittle it down some.
Just to be clear, that's the Cellbrite with the website pages.
I will be using the website page for the non-extradition countries, but not the emotion.
Okay, we're good. That's all I have for now, Your Honor,
Very well.
on this issue.
As to slide 20, I will review the entire email chain and then make a rule.
So they mentioned there's some discussion about the non-extradition cities. And from my perspective, and there was something else I want to mention about those other text messages. But those non-extradition cities, we know some stuff's going to come in about that, but there's some stuff they're not going to fight about. Not 100% sure exactly how it's going to come out, but I can almost guarantee you that's going to come out. That's going to be new evidence we haven't heard in any of the other trials. And secondarily, those text messages about he was telling the truth, we shouldn't have to pray, praying hands emoji, I love you, mom, call me when you can, between Wendy and Donna, was right after Charlie was convicted by the jury, right after the verdict. So brand new text messages. And my guess is those are not the only text messages. Those are just the ones we're hearing an objection on. So I think we're going to have searches done by the Adelson parents. I think we're going to have plane tickets bought. I think we're going to have emails and text messages. We're going to have jail phone calls, probably all done post Charlie Adelson conviction that we've never really heard before, never heard come out at trial, didn't come out at Magbanwa's trial, didn't come out at Charlie's trial or any other, issues or hearings that they've had on this case before. I think there's going to be a chunk of new evidence and information that's going to make Donna Adelson look more guilty or consciousness of guilt or fleeing or things like that, that were not available potentially before she was arrested, before Charlie Adelson was convicted. So people are asking about how these things are building on each other. I think this may be one of the ways. Jenny said about the stash, giving people strong opinions about stashes. Do you consider that in the courtroom with jurors? So I never have. I've never done a stash. I usually try to go with like my most normal look, which, beard, hair, normal, try not to get too long of the hair. Although I did get a good verdict one time when my hair was like entirely grossly long. But I don't know, I kind of go back and forth. I kind of want, if people are disgusted by something they see, if they're looking at me or don't like me or hate me, I want it to be so visceral that they tell me. And if the people happen to love it, then great, come on and be on my jury. So I go back and forth, but I usually just try to go normal. I wear a normal suit, a normal tie, a normal watch, nothing super fancy, nothing super loud, just kind of down the middle, and let the evidence be presented in what the jury decides on, not that they don't like a pink tie or something if I happen to wear that. So usually that's kind of my trial thought and strategy. Rebecca, hit that like button, y'all. Show some love. Yes, would you please hit the like button? These lead ups to the trial sometimes are slow, but I want everybody to be on the same page, know what we know going forward. And the next thing that happens here is an officer gets put on the stand again, a continuation about talking about these summary reports and whether or not they're going to come in. Summaries usually don't come in. The defense does not want this summary report of all these emails and text messages to come in, to place people in different places, to connect all these dots. He said it's basically a closing argument. They can always be used as a demonstrative aid, and we've seen other cases with summary exhibits where the jury's like, can we get that summary exhibit? The judge is like, no, it was just a demonstrative aid. But there are certain circumstances where summary exhibits can come in. And this is the part I was talking about off the top of the video, which is like, I wish I could see the summary exhibit, then I could give my better legal opinion. But just based off what they're telling, I can't really tell whether or not I agree with the judge's ultimate decision or not. Usually, I don't think summary exhibits should come in. I think it's not really an appropriate way. And usually law enforcement summary exhibits somehow make it in a lot more than like a defense expert's summary exhibit for one reason or another. But we're going to listen to the judge's ruling and kind of hear how he ends up making this decision on the summary exhibit of all the emails, text messages, all these voluminous documents, hundreds of thousands of pages that this officer's kind of put into a summary that he's going to present. The state can use at closing and can be a demonstrative aid. Everybody kind of agrees with those three things. It just comes down to, can the actual summary exhibit go back as a piece of evidence for the jury to determine while they're, or to look through while they're deliberating?
Thank you. All right, as to the rulings on this matter, the court has previously ruled that Sergeant Corbett can be qualified to testify to the interpretation of historic communication data. The summary will be available to the state as a demonstrative in front of the jury. Also, in researching this matter, I came across a recent case of the 3rd DCA dealing with summaries, which I believe has a relevant ruling to this matter. This is EJD Construction Contractors and Investment Corporation versus Preston, found at 306 Southern 3rd, 1053. And ultimately, the 3rd DCA held when a summary is accurate and not misleading, it can be properly admitted during trial. The summary may also include opinions by the individual preparing the summary, as long as the opinion is based on the underlying evidence and data that is admissible. To that point, the court will permit a summary to be admitted to the jury. However, the summary may include a page cross-referencing all voluminous records or state exhibits that Sergeant Corbett used in forming his opinion, his method of analysis, and the conclusions that he reached, or any inferences which may be properly drawn from the evidence. The summary is not to include any cumulative repetition of admitted state exhibits, and this is specifically going to matters such as emails, text messages, videos, things of that nature. Any inadmissible information or any opinion the witness is not qualified to give. This is going to cut down the pages that actually go back to the jury, but a summary that is based on the voluminous records and exhibits and the opinion that was reached by the sergeant that is proper and meets the definition of a summary pursuant to 90.956 will be permitted. Any additional objection that needs to be raised at the time this is offered, the defense may raise at that point. The parties need any clarification on the ruling.
No, sir.
So he is going to allow it in. There are ways it could still be objected to or kept out if there are certain things that are inadmissible that he's relying on, if something comes up wrong with it, the way that he testifies to it, if there's something wrong in the summary exhibit. But generally speaking, if he does everything right and they check all the boxes, like the case that the judge mentioned he found when he was doing research, the summary exhibit is going to be allowed to go back with the jury in evidence as an exhibit. And again, usually I would disagree with this, but I can't say in this case because I haven't seen the summary exhibit. I haven't seen how it all comes out. So this is subject to change potentially for the judge, but generally speaking, he's going to probably allow the state to do this, which is a big win for them, for the jury to see all this connected as an exhibit going back, and it's evidence. And juries put a lot of credence in something that is evidence, and sometimes they forget a lot about what was said or argued, and they look at the evidence themselves, and this is going to be back there connecting all the dots. The defense called it a closing argument, basically. And so they really did not want this to go back with the jury. He's explaining this to
And just so it's clear, as far as the call record summaries, and I believe the arrow charts, those will be permitted as far as being in the summary itself. The location maps, that will be permitted as well. But again, all of the other matters that are not voluminous themselves, such as any emails, text messages, or videos, it can be cross-referenced as to what the sergeant used, but it will not be a part of what is admitted.
Is there, like, if there's one text that can be an exhibit and he can cross-reference, I used exhibit 3 in this summary, and that text doesn't have to go back in the summary as well, just procedural things.
Demonstrative itself, though, can be used as the state would like to use it. Ultimately, for that, if there are any inadmissible items that still need to be ruled upon, I believe slide 20 is the only one outstanding. I will give you a ruling on that matter before it is to be used even as a demonstrative. There are no questions. We are finished at this time. I will see everyone on Tuesday morning at 8.
All right. So they start Tuesday morning at 8. So I guess it's Tuesday they start, not Monday. So that's going to be Tuesday, Wednesday, Thursday, just 3 days of jury selection, not 4 days of jury selection. That was my mistake earlier. So 3 days of jury selection, then about a week of the state's case, couple days of the defense case. And then we have another verdict in this case as the Markell family continues to march towards justice. Donna Adelson is presumed innocent. They have gotten a lot of different pieces of the conspiracy. Is it over? Was that the totality? Is Donna Adelson a bridge too far, or is she in the midst of the conspiracy? Additionally, people are always asking, how about Wendy Adelson? Why isn't she charged? I think she had something to do with it. I'm not saying I think that. That's what this comment says. Here's what I think. I think if the state has enough evidence, they will prosecute her. There's certain kinds of immunity she's gotten that we've broken down in other trials, in other videos. But generally speaking, if they think that they have enough evidence to convict her beyond a reasonable doubt, and there are no hurdles in the way or blockade in the way of them doing that, then nothing has stopped them in the past from once they convict one, take the next step to the next. Will it be Harvey? Will it be Wendy? Will it be somebody else? Only time will tell. But right now, everybody is focused on Donna Adelson and her potential involvement in this conspiracy to take the life of Dan Markel. So that's all we've got for this one. Make sure you guys hit the like button if you have not already. Make sure you subscribe to our page and hit that reminder bell so you don't miss any of the videos that we're going to do on this trial, hopefully starting next Friday if they get a jury picked. But that's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.